Oh, and on this one, Mr. Beckett. Sorry, actually, Ms. Beckett, Amy Beckett. Mr. Curran, if you could keep it silent and have her sign it. That's done. Thank you. I believe so. I'm not changing this, I'm just making, there was a cross out and a correction, so I'm gonna use my tape here and make this a little bit cleaner, if that's okay with the parties. All right. And would all parties like a copy of all of them? All right, if you all have a seat, we'll get copies to everybody and we'll get you served, okay? Thank you very much. And then, Mr. Kern, you have a couple other cases that I think are pending service. You've got Ashley Marshall versus Justin Marshall. Oh, you're Mr. Marshall. You, Miss Marshall? I think we need an ex parte. This, we'll need an ex parte that'll keep the same terms in place. And then, do you all want to set it over? I've got October 24th or I've got November 21st. Is November okay for you, Mr. Kern? Okay. November 21 at 9 a.m. for review. And then, Ms. Marshall, you understand that Mr. Marshall is represented by Mr. Curran, that if this were to go to hearing, I have to hold you to the same standard I hold attorneys to, and that puts you at a significant disadvantage. Okay. All right. Is Mr. Marshall here? I just need to get him served with the ex parte. If he can come in sometime this morning before noon, that'd be great. Okay, that sounds good. Thank you very much. Okay. I think you have one more. Yeah. Okay, there is two Justin Marshalls. So, Madam Clerk, on numbers 3 and 4, we'll need ex partes. We set this over to November 21st on both of them for hearing. He represents Mr. Marshall. Miss Marshall is present. Oh, we don't need the backup. I think so. Thank you very much, Mr. Curran. If I need you, I'll know where to find you. Thank you. No, there's just two. It's just split up between the pages. Oh, is there enough? So, Mr. Curran, there's actually three martial order protections. So we'll do the same date on all three, and then we'll have ex partes for all three. And do you need me to appoint Ms. Gustafson on these for the motion to renew? Do you need Ms. Gustafson in on the motion to renew? Okay. I will go ahead and do an order in all three cases to get her back in. Thank you. Not a problem. He is going to come in during the course of the docket for us to serve him. So we'll get the ex partes printed out and filled out, and then when he comes in, we'll serve them. Okay. Jared Harper, thank you, sir, coming up. Good morning, sir. Bonnie Harper. Bonnie Harper. I can put this on for my first one if you want to set. I've got to put it on the record. It doesn't have to be extensive, but. Mr. Brown. Mr. Rohr, I'm here with Mr. Brown on the Shots v. Shots case. Let's see if we can find him. Mr. Rohr, can you hear me? If you'd put it on recall. All right. Linda Sue Smith, CPAC. Come on up, ma'am. Morning, ma'am. So, ma'am, on this motion to renew, it looks like we don't have service yet. Okay. We don't have service on Mr. CPAC. We've got to get service before we can continue, unless we are. So we'll need an ex parte. All right, so ma'am, we'll try again to get service on Mr. CPAC. I understand that, but unfortunately with the motion to renew, we do have to get service, but I'll issue a temporary order today that will fill the gap, okay? So I can set this over to October 24th. I can set it over to November 21st. Okay? Of this month? Thank you. So I don't have, at least in Camden County, I don't have any pending criminal cases for him that I show. Yep, he's on probation, um, but he doesn't have a pending court date anywhere. So let's do this. Let's set it out to November 21st at 9 for hearing. Do you know how to check the case on CaseNet? Okay. So if we get to November, okay, like look at November 20th, if you still don't have service, rather than coming all this way, you can appear via WebEx or call the clerk and make a motion for a new date for service. Okay. But you need to stay in touch with the clerk's office. You know, you may need to request that a new summons be issued. You may need to look into hiring a special process server if they're having a hard time getting him served. Okay. So, yes, right now it's been returned non-est, which means that they won't try and serve it again because they've tried to serve it and it says that it was expired. So you'll need to go down to the clerk's office and ask them to reissue service, okay? All right, thank you. Mr. Rohr, can you hear me? Mr. Rohr?
Sorry, Anna, were you looking for me?
I was. I have you on a couple cases. The first one is with Mr. Brown on the shots v. shots. Mr. Brown, actually, if you want to get behind a microphone. Mr. Brown is here with his client. I believe that his announcement was proceed to hearing.
So
Yes, Your Honor.
I'm over here in Miller County right now with just actually was out talking to her dissolution counsel because there's a dissolution of marriage action pending also here in Miller County. So he still has a municipal charge pending. So we would request, we're not opposed to the temporary order being continued at this time, but until we see if I can get something worked out that we could do in the dissolution here and then get the other case resolved first before we had a hearing. I'd appreciate that.
Mr. Brown?
And Judge, I appreciate his request. However, my client does want to proceed at trial at this time.
Okay. Did she talk to her attorney? Her other
Dissolution
attorney?
Yeah.
Okay.
And Judge, I did research, and I mean, I know child order protections this isn't a child order protection, it's adult order protection. I've looked under the statutes. It is independent. She wants the remedies under the order of protection that she can't get in the dissolution. And that's why she's here today. And there's some, she has pretty serious allegations I believe we can prove. And so that's, why we're here.
Well, I can set a date. Like I said, I usually give each party one continuance. Mr. Rohr's physically not here today. I can set this for a hearing date, the understanding that'll go. I've got October 24th and November 21st. Do either of those dates work for the parties?
I'd ask for, I apologize, what was the first date?
October 21st, or sorry, October 24th or November 21st.
Both those dates don't work for me. They don't work. And I assume one of the cases that Mr. Rohr is referring to is on November 13th. So I don't know if there's even a later date and just keep the ex parte in place. I'm fine with.
I could do December 5th or December 19th.
December 19th.
I could do the 5th. The 19th, I have a trial here in Miller County.
Could it be like a 11 o'clock or a 1 o'clock docket, or I have a dissolution in the morning?
Could we put it at like 11?
Yes.
Okay.
I have a show cause. I have a show cause hearing at 11. That's why it was like the morning at work. I don't think it'll take that long if we wanted to set it after lunch, like at 1:30 or something like that.
That's fine with me, if it's okay with the court.
Do 12:05 at 1 for hearing.
Okay. Thank you, Your Honor.
Thank you, Judge.
Thank you. And then, Mr. Rohr, Ms. Drake appeared on the Kazmarek with Kazmarek, and she indicated that you all were trying to work something out in the dissolution and asked that it be passed to November 21st at 9.
That is correct, Your Honor. We're also waiting for some discovery too, so that would
Okay.
that'd be fine.
Okay. Oh, and then I'm not sure that you've been made aware, but the court on the Michelle Fortenberry versus David West, I had assigned you as the GAL in that case.
Fortenberry,
Are
the
you-
West. Okay.
David West. David West.
Don't believe I've been contacted by either of those parties.
Okay. All right. So I've got Ms. Fortenberry here.
Okay.
So Ms. Fortenberry, in the child order of protection, because there's been allegations of abuse, by statute, I have to have a GAL, which is an attorney for your child. Okay. And so I've appointed Mr. Rohr as the attorney for that. Mr. Rohr, is there a good phone number I could give her to reach out to you to?
Absolutely. 573-348-3313.
All right. Yeah. So there is a temporary order in place in all these cases, and that will remain in place. Okay. Mr. Rohr, what would be a good date for me to reset this to? Do you want later in the month? Do you want November?
Let's go ahead and do that one on the I can't do that one. How about the 24th? I've got a trial, but it's in Camden County, so it wouldn't take, I mean, I'm sure I could take a break to take care of this one.
October 24th?
Yes.
All right. Let's do 10/24 at 9. And then Ms. Fortenberry will be reaching out, and she indicates that Mr. West is incarcerated.
Oh, okay, all right.
All right. And I think that's all I have for you, Mr. Rohr. Thank you very
Okay.
much.
Thank you very much, Your Honor.
So Ms. Fortenberry, you have an adult order protection and a child order protection. I like to keep those together because generally they're a lot of the same evidence. So I'm going to move those cases. They'll both be set on that October 24th at 9 a.m. They are still valid. They are good. You're welcome. Discuss. Morning. Mhm. Yes, November 21st on all of those. And then I'll get an official order since it's a motion to renew. He had set it for hearing at that time, but you might want to check with him. So, and there'll be an ex parte issued as well to hold those over. Madam Clerk, was Ms. Gustafson on any other cases that she didn't get notice of? We had a lapse in the clerk's office where they didn't tell you that you were a GAO on some cases. Yeah. Amber Flower, Randall Hussey. Amber Flower, Randall Hussey.
Amy Beckett. Stephen Beckett. Oh, I'll come in.
I think that she filed something. Oh, she's got a court date at the same time. So, do you have a preference on? Yeah. And there's, okay, so it's number 28, number 29, and number 33. So I've got October 24th or November 21st or December 5th. There are. And it looks like there's been a juvenile. They have an investigation open. Killing it. All right. Now, do you know which case this is? Thank you very much. Ms. Birdsong, if you want to get your client up here, we'll go ahead and put that on the record. Jessica Lynn Wallace. All right. Elena Hawkins. So Ms. Wallace, and actually, if you'll have a seat right where I can get you behind a microphone. So Ms. Wallace, I don't have service on Ms. Hawkins yet, so I need to get you a new date for service, okay? I can set this over to October 24th or November 21st, Thursdays. The 24th, okay. 10:24 at 9, and that'll be for hearing, okay? Thank you very much. This is number 11. Court calls case 24-CM-PN00045, Jared Harper versus Bonnie Harper. Mr. Harper appears in person and with his attorney, Ms. Birdsong. Ms. Harper appears not, although upon review of court's file, she has been personally served in September 26th. Ms. Birdsong, are you prepared to proceed today?
Yes, Your Honor.
Will you call your first witness?
Call Jared Harper.
Mr. Harper, if you'll please stand where you are, raise your right hand and be sworn.
Do solemnly swear the testimony you're about to give in the cause now pending before the court shall be the truth, the whole truth, and nothing but the truth, so help you God.
You may be seated. Ms. Birdsong, you may inquire.
State your full name for the record, please.
Jared Stephen Harper.
And Jared, you are married to Bonnie Harper, is that correct?
That's correct.
And you're, you have to speak up just a little bit.
That's correct. I'm married to Bonnie.
And you reside in Camden County, is that correct?
That's correct.
And you also have 3 children in common with Ms. Harper, is that also correct?
That's correct.
And you filed a petition for an adult order of protection, is that right?
Yes, ma'am.
And on or about September 12th, 2024, you're separated, is that right?
Yes, ma'am.
And Ms. Harper's been staying in a residence that you own, is that condo that you own, is that correct?
Yes, ma'am.
And you've been staying in the marital residence with the children, is that right?
Yes, ma'am.
And on or about 9/12 of 24, did Ms. Harper come to the marital residence that you were residing in with the kids?
Yes, ma'am.
And do you know why she was there?
She wanted to get some documents. She wanted to get an extra key to her truck, and she was asking for a pistol.
She was asking for a gun?
Yes, ma'am.
And prior to her arriving at the home asking for a gun, had she been sending you text messages that caused you concern?
Yes, ma'am.
Were you concerned about her mental health when she arrived at the home and asked for a gun?
I was.
And I'm going to show you what I've marked as Petitioner's Exhibit 1. It's a stack of text messages, is that correct?
Yes, ma'am.
And these text messages refer to spells cast on you, is that correct?
Yes, ma'am.
And they refer to Azrael, who we've figured out is the god of death in Islam, is that correct?
Yes, ma'am.
And she mentions wanting to have the need for a wood chipper, is that correct?
Yes, ma'am.
And in multiple instances, she refers to you being DOA, dead or on arrival, and things of that nature, is that right?
Yes, ma'am.
And are all these text messages a fair and accurate representation of the text messages you've received from Bonnie.
Yes, ma'am, that's correct.
I'd like to offer Petitioners Exhibit 1.
Petitioners Exhibit 1 shall be admitted.
When you told Bonnie you were not going to give her a weapon because you were concerned about her mental health, what did she do?
Well, I texted her and I said I didn't want to give you that, and I didn't hear from her. And then she just showed up at the house.
Okay, and at some point she ended up in the room looking for the gun, is that correct?
That's correct.
And did she get the gun?
She did.
Okay, and what happened at that point?
I tried to stop her. I said, no, please stop. I don't want you to have it. I tried to, get the weapon from her, and she didn't want it, or she didn't want me to get it. She was shoving and pushing and hitting, and
Did she threaten to shoot you with a weapon or hit you with a weapon?
she did, yes, ma'am.
What was the threat that she made?
I'm gonna cold clock you with this.
And has she also made many references online about all of your family being pedophiles and her boss being a pedophile and things of that nature?
Yes, ma'am.
And are you concerned for your safety at this point due to her mental health?
I am.
Are you asking the court to enter a full order of protection?
Yes, ma'am.
And that would include no contact, even in regards to your children at this time, is that correct?
Yes, ma'am.
And is that because that she needs some serious psychiatric help, and until she gets that, those conversations would likely be unproductive?
Yes, ma'am.
Thank you, Mr. Harper. Your Honor, I don't believe I have any further evidence.
Thank you. Ms. Birdsong, in the temporary order, there was an exclusion zone of 100 feet. Are you requesting that?
Yes. You need more than 100 feet?
I mean, the further the better, but it's whatever the
I
court
think
thinks is
if we
appropriate.
could do it further, Your Honor. She's already broken into the residence and violated the order, so I think we probably need some more distance than that.
Does Mr. Harper work, or would you like an exclusion from his place of business?
Is there any place where you report to work?
No.
No, Your Honor. We do have separate child protection orders that exclude the schools, so that are currently in effect, set it on a different day.
And then what's the length of time that you're asking?
6 months or a year.
Probably a
You can
year.
always a year,
Years
Your
or-
Honor. You can always dismiss it
Walk
and
it back.
modify it, yeah.
Evidence has been adduced upon due consideration in the matter. The court finds pursuant to section 455040 that the petitioner has proven allegations of domestic violence against the respondent. The respondent cannot show that her actions alleged to constitute abuse were otherwise justified under the law. The court therefore finds the following. The relationship between the parties was that of a current spouse. The court further finds that the respondent represents a credible threat to the safety of the petitioner. The court finds that she poses a serious danger to the physical or mental health of the petitioner and of the minor children of the petitioner. The court considered all relevant evidence, including but not limited to the testimony of the petitioner, which the court finds to be credible. Exhibit 1, which details text messages from the respondent, which indicates a severely disturbed, mentally unstable person with ideations of violence. The court also considers attempts by the respondent to obtain a firearm, which is consistent with some of the text messages that are contained therein, and the physical violence perpetrated against the petitioner. The court therefore orders a full order of protection, which will replace the temporary order entered by this court on September 19th of this year. Court orders that the respondent shall not communicate with the petitioner in any manner or through any medium. Use of third parties, including children, is strictly prohibited. The respondent shall not commit or threaten to commit domestic violence, molesting, stalking, sexual assault, or disturbing the peace of the petitioner wherever they may be found. The respondent shall not harass, stalk, or threaten, or engage in other conduct that would place the petitioner in reasonable fear of bodily injury. The respondent shall not attempt to use, or threaten to use physical force that would reasonably cause bodily injury. Petitioner is granted exclusive possession of his premises, and the respondent is forbidden to enter or stay at the petitioner's residence. Court further finds that in order to ensure his safety, the respondent shall not come within 250 feet of the petitioner. Court further finds that as a result of a hearing at which the respondent received notice and had an opportunity to participate, and is the spouse of the petitioner and represents a credible threat and is restricted from harassing, stalking, or threatening the petitioner, that federal law prohibits her from possessing, shipping, transporting, and/or receiving any firearm during the duration of this judgment. Judgment shall be in effect for 1 year until October 9th of 2025. That will be the order and judgment of the courts today. With that, we can go off the record. I'll get you a copy. Would you like a copy of that, Ms. Bertzel? I'll let you retrieve Exhibit 1. Have you had contact with Ms. Spear regarding the GAL on the other ones? They didn't enter her as a GAL, so she may not know about it. So we will do that today. Nope, they're on the 24th. Yep. All right. If you are here today, you are here on an order of protection case, right? Before we begin, there are some things that you need to know about the order of protection cases. First thing is that these are formal cases, right? That means a couple things. Number one, all testimony is taken under oath and it is recorded. Those recordings are available to law enforcement, to other attorneys, and to the public with a sunshine law request. If you have other cases pending, be they civil or criminal, your testimony here today may be used against you in those court cases. Okay? So you need to be very careful about testifying if you have other things pending. If you are prosecuting one of these cases, okay, you need to know that you have a legal standard that you need to meet. That legal standard changes based on your relationship to the parties and based on what you have pled in your petition. I can't tell you what that legal standard is. That's not because I'm trying to hide the ball for you or make it harder. It's because that would be me giving you legal advice and acting as your counsel instead of acting as a neutral third party. I will tell you it's very hard to meet a standard if you don't know what it is that you're trying to prove, all right? In all of these cases, I have to hold you to the same standard I hold an attorney to. That means rules of evidence apply, hearsay, exceptions and objections, laying the foundation for the admission of evidence. If it sounds like I'm talking in a different language, that's because these are difficult things, all right? And if you don't understand them, it can severely restrict your ability to present the case and the evidence that you wish the court to hear, right? If you are defending against one of these cases, you need to know that if the court does find an order of protection is warranted, it will be in place for a minimum of 1 year. It may be in place for the rest of your life, right? These are serious cases. People tend to think that because they can file them without the aid of an attorney, that this is an easy thing. They're not. They have severe consequences. All right. If the court does order an order of protection, it will severely limit, if outright prohibit you from owning or possessing firearms, and there may be other legal consequences. Right. The other thing is, if you tell me you are ready to proceed today, you are telling me that you have all the evidence you need with you. Right. There is a common misconception that I have evidence to police report, or I have access to police reports. I do not. Okay. I don't have access to anything unless you bring it with you. Right. So if you have videos, if you have paper documents, if you have police reports that you need me to look at as part of your case, and they're not holding them in your hand, you are not ready to proceed today. All right. Same thing goes for witnesses. There is one case today that I have allowed testimony by WebEx. If you have not received an okay from the court ahead of time to testify via WebEx, you cannot present testimony remotely. All right. So if you don't have your witness sitting next to you, you do not have the evidence you need to proceed today. Once we start a case, we will finish a case. So if you tell me you are prepared to proceed, you need to make sure that you are prepared to proceed. If the court does start a case and finds that an order of protection is not warranted, right, that would forever foreclose you from bringing up those allegations again in the future. It may impact any other cases that you may have regarding those claims, right? So, knowing all that, you all have three options today. Number one, if you want more time to gather evidence, talk to an attorney, hire an attorney, I will give you more time within reason to do that, right? Number two, in a lot of these cases, I've entered a temporary restraining order. If the parties are abiding well underneath that, you all can enter into what's called a consent judgment. In a consent judgment, there is no hearing, there's no evidence permitted, there's no admissions made. It is an agreement between the parties to enter into an order of protection, all right? The last thing you can do is you can tell me that you are prepared to proceed without the assistance of counsel. You're telling me that you understand the risk that you are facing by proceeding without counsel, and that you have all the evidence you need and you're prepared to proceed. All right. So is there anyone that is wishing for more time to
Stream cut out,
gather
so I
evidence or talk to counsel before they proceed? Yes, sir. Okay. You're Mr. Martin, is that right? Is John Cairo here? All right. I can do October 24th. Mr. Cairo, are you available on that date? So, Mr. Martin, what I can do is this. I can put you at the end of the docket, okay? If you need to go get whatever you need to get, and let me call the other cases, and we'll take this up at the end of the docket. All right. Why don't you all come upstairs? All right. Why don't you both come on up here? as far as protecting you from legal implications, a consent judgment means that the court makes no findings and you make no admissions. There's no evidence presented.
Yeah, I used
that's
to
something
do
you
hard
saw
drugs
a
that
lot
way.
of
That's how I
attorneys
started doing hard drugs. I never
advocate
smoked it before. I just
for
used to shoot it up.
consent judgments because that protects their clients from having to testify or make any admissions. But sir, it gives you the same order of protection that you're seeking.
Mix me with that shit, you know I live in the mix. Money car.
So what I mean is we're not continuing the case. We're going to enter into consent judgment. So there'll be an order of protection entered today. Huh? I don't think you understand me. So you're asking for an order of protection. He's consenting to an order of protection. Yeah. So that's what we're going to do. There is an order of protection. Yep.
I was like, fuck this. I'm not doing any more of that shit. So I just started doing a lot of cocaine. Cocaine is where it's at. Word. Dude, cocaine is a hell of a drug for me. I am super bad at cocaine. My brother used to sell cocaine, and man, that shit was bad. I owed him like $1,400 in fronts. That was just because I'd get off of
You all are just acquaintances, right? So the terms on the temporary was no communication. Is that agreed upon by the parties? Okay. And shall not commit or threaten to commit domestic violence, molesting, stalking, sexual assault, or disturbing the peace of the petitioner. There's no allegations concerning pets, right? There's no allegations concerning pets. Pets, like dogs and cats. Okay, that's okay. So, sir, you agree you shall not harass, stalk, threaten, or engage in other conduct that would place him in reasonable fear of bodily injury. And you agree you shall not use, attempt to use, or threaten to use physical force. And then in the previous one, there was a 50-foot exclusion zone. Are you okay with that? Okay. Sir, are you okay with 50 feet? Okay. Are there any other terms or conditions that the parties wish to discuss? Well, and hang on. So he's agreeing, so I don't need to hear evidence, okay? But because we're agreeing, that's okay, because we're agreeing. So there'll be an order of protection in place for a year with these terms and conditions, which is what you've asked the court for. Is there anything else that you are requesting as far as the conditions in here that we need to discuss? Okay. Mr. Martin, you have a copy of this, you'll be free to vote. You may. Okay. All right, Mr. Marshall, come on up. Let me get these signed and. No, that's not a problem at all. There's, I was just looking, there's, so no communication except for written communication regarding the care, custody, and control of the children. The standard not to abuse, and then not to be within 500 feet. And is there there's an exclusion for the family home as well, is that correct? And that we put this in. Mr. Kern, if you want to take a look at that, make sure that that's what's agreed upon, and then I will get Mr. Marshall served here. Yes. Mr. Marshall, if you want to have a seat, sir, we'll get copies of this and get you served, and you'll be good to go, okay? Thank you very much. Thank you for bringing him in. One more for you. Was there anyone else that was wishing for more time? Yes, ma'am. Yes, please. What's your name, ma'am? I know that we had continued the other West cases. Are you wishing to continue to that same date? That's okay. That's not a problem. If I set this over to October 24th at 9 a.m., that work for you? 10:24 at 9. Temporary orders will remain in place, okay? Thank you very much. Mr. Wesson is not here. She's asking. He's not here. Nope. He's incarcerated. But he's also the respondent in the Fortenberry cases, and we've moved those already to 10:24. We're gonna keep them all together. All right. You guys are good to go. Thank you very much. Yes, ma'am. Sure, come on up. What's your name, ma'am? Let's find you here. Okay. Is Jordan Sharp here? Come on up, Mr. Sharp. Madam Clerk, can I have a motion, please, or a memo? This is number 19. So, Mr. Sharp, Ms. Sanford has been trying to get discovery, and what you need is what I'm going to give you, which is an order to comply. And so they are going to, I'll order them to give you a copy of the police report. Mr. Sharp, are you missing any discovery that you are wishing to have, that you're having trouble getting? So she is asking for a continuance today to get this. What I can do is leave the temporary in place and set this out either into November or December, so that you're not driving back up here every week. Okay. Um, and I remember us talking about that last time. We've got, I mean, a couple of things we can do, okay? I'll give you permission to appear via WebEx. So, and I have people that are in the armed forces that have appeared via WebEx to present your side of the case, so that may solve that. You'll have to show them, you know, your commanding officer that you do have a court date on this. I can also set it out farther and allow you to complete basic training, or we can enter into a consent. Have you all filed a paternity case or anything like that? So, so what we have here today is just the adult order of protection, okay? And there's already a full order of protection in place. And ma'am, on your motion to modify, um, So as far as discontinuing visits, there's no visits that are contemplated in the plan or in the order of protection. Do you understand that?